This lecture will be covering chapters 9 and 10 in our Medical Law and Ethics class. Chapter 9, the medical record. The medical record contains all written documentation relating to the patient, including past history, current diagnosis and treatment, correspondence relating to the patient, a legal document that may be in the file would be a subpoena, also referred to as a subpoena ducis tecum, or there also may be a patient authorization form releasing those records. The purpose of the medical records, it's a record of the patient from birth to death, documents for continual management of the patient's health care. It provides data and statistics, tracks ongoing patterns of the patient's health. Other contents of the medical record include personal information about the patient, clinical data and information, records of medical examinations, including x-rays, lab reports, consent forms, referrals, PT or OT, prescriptions, and refill information. Other contents of the medical record would be admitting diagnosis, evidence of a physician examination. Please note that not more than 7 days before admission or 48 hours after admission to the hospital, there should be this examination, documentation of any complications, and signed consent forms. Other items include consultation reports, physicians and healthcare professionals' notes, a discharge summary with follow-up care. The medical record should never contain irrelevant material. Corrections and alterations. Errors require correction. Nothing, however, should be deleted. A note in the margin of the record as to why the change was made. Use black or blue ink. Draw one line through the error. Write the correction above the error. Date and initial the change. Do not erase or use correction fluid. Corrections and alterations. Electronic medical record corrections, also referred to as EMR. Falsification of medical records is grounds for a criminal indictment. Timeliness of documentation. Medical records must be accurate and timely. All entries must be made as care occurs or as soon as possible afterward. It should be completed by the physician within 30 days following the patient's discharge from the hospital. Completeness of entries. Medical records document the type and amount of patient care that was given. In the eyes of the court, it is not documented, it was not done. Credibility. Believable or worthy of belief, trustworthy and reliable. Credibility gaps should be avoided at all costs. Other problems may be illegible handwriting, delays in placing tests and results into the file, any contrived or invented documentation. Ownership of record. Physicians or owners of healthcare facility own the medical records. Patients have a legal right of privileged communication and access to the records. Patients can be given a copy of their medical records. Patients must authorize release of medical records in writing. Doctrine of professional discretion. A physician may determine, based on his or her best judgment, if a patient with mental or emotional problems should view the medical record. Confidentiality. Medical records should not be released to a third party without the patient's written consent. Only specific records requested should be copied and sent. Taking photos or other visual images of a patient's record without consent is an invasion of the patient's privacy. Release of information. Never send the entire medical chart unless it is requested. Never send the original. The release of information. A patient must always sign a release form. Only a patient can authorize the release of his or her own medical records. The record may not be released to a patient without the physician's permission. A patient must sign a release form for information to be sent to an insurance company. State open record laws. Some states have freedom of information laws that grant public access to records maintained by state agencies. Medical records generally are exempt from this statute. Alcohol and drug abuse patient records. Public Health Services Act protects patients who are receiving treatment for drug and alcohol abuse. A person or program that releases confidential information relating to these patients is subject to criminal fines. An exception is if a patient should require emergency care. Retention and storage of medical records. Each state varies on the length of time records must be kept. Legally, records must be stored for a minimum of 10 years from the time of the last entry. A minor's records must be kept until the patient reaches the age of maturity, plus the period of the statute of limitations. Due to limited storage space, medical records may have to be destroyed after a period of time has elapsed. There are certain conditions for the methods of destruction of medical records. Storage of medical records. Current records usually kept within the physician's office. A former patient's records may be stored elsewhere, may be stored at an off-site rental facility, may be placed on microfiche, kept in a fireproof, locked area. Electronic medical records. Data on patient records can be created, modified, authenticated, stored, and retrieved by computer. Special measures should be taken to establish identification and user verification codes for access, such as passwords, encryption, and firewalls. Electronic medical records should be accessed on a need-to-know basis. Not everyone in a healthcare facility should have authorization. The loss of medical records. This can be very frustrating, even harmful to all parties involved. Safeguards should be and can be implemented, such as journals, color-coded inserts, or other indications, designated a sole individual responsible for maintaining the records, and having some type of backup, either microfiche or electronic files. Reporting and disclosure requirements. State laws require disclosure of some confidential medical record information without the patient's consent. Reporting and disclosure are duties of the physician. The use of medical records in court. Improper disclosure. A healthcare provider and institution may face civil and criminal liability for releasing medical records without proper patient authorization. A supplica ducis tecum is a written order requiring a person to appear in court, give testimony and bring information described in the subpoena. Chapter 10, Patient Confidentiality in HIPAA. Confidentiality. Physicians are expected to maintain all confidences concerning their patients. Modern medicine and technology make patient privacy issues a paramount concern. Confidentiality preserves the patient's dignity. It is the minimum standard. Our right to privacy is not protected specifically by the Bill of Rights or any portion of the Constitution. AIDS and privacy. AIDS threat to all persons. Therefore, information needs to be carefully communicated. The Privacy Act of 1974. An agency may maintain only information relevant to its authorized purpose. Citizens have a right to gain access to records and to copy records if necessary. It applies only to federal agencies and government contractors. The Health Insurance Portability and Accountability Act, also known as HIPAA, was signed into law in 1996. It regulates the privacy of patient health information, has 4 objectives: improve portability, combat fraud, abuse, and waste, promote the use of medical savings, and simplify administration. The 5 major categories covered under HIPAA: insurance portability, administrative simplification, medical savings and tax deductions, group health plan provisions, and revenue offset provisions. Privacy rule applies to protected health information, PHI, limits disclosures to only the minimum information necessary to carry out the medical treatment. A patient must grant written consent or permission to disclose their PHI for treatment, payment, and other healthcare operations. The High-Tech Act, which is the Health Information Technology for Economic and Clinical Health Act. It's meant to promote the adoption and meaningful use of health information technology. It created Electronic Health Records, EHR, and Notice of Privacy Practices, NPP. Release of information and consent. Patients have the right to know how, when, and why their medical information is used. Providers can refuse treatment without consent. Exceptions would be emergency situations, language barriers, and prison inmates. Who are affected? Public health authorities, healthcare clearinghouses, self-insured employers, private insurers, and information systems vendors. Others that are affected would be various service organizations, universities, healthcare plans, treatment, payment, and healthcare operations. Covered transactions, healthcare provider submitting an electronic claim, a physician sending PHI to another physician, a physician sending PHI to a billing service. Denial of the request for privacy. Some healthcare institutions, such as nursing homes, may have to deny access to a patient's medical information in order to protect the patient. A state's preemption. Some states have stricter privacy standards than those established by HIPAA. Those states' laws would then take precedence over the federal HIPAA regulation. Unique identifiers for healthcare providers. Standard identifiers are used to reduce confusion and errors. Employer Identifier Standard, published in 2002, uses the employer's tax ID number or the Employer Identification Number, the EIN. Can protected health information, PHI, be de-identified? To de-identify patient information, you must remove the patient's name, address, including email, telephone and fax numbers, all dates, including birth, except the year, admission, discharge, and death. You must also remove the Social Security number, medical record numbers, health care insurance numbers, license numbers, facial photos, other identifying numbers or characteristics. Obligations to patients under HIPAA: obtain consent and authorization for any disclosure of medical information, permit patient access to medical information, provide only the minimum necessary standard, permitted and incidental disclosures. Penalties for non-compliance with HIPAA: there are civil penalties, federal criminal liability with sanctions and time in prison, risk of a class action suit and public relations damage. Health Integrity and Protection Data Bank, the HIPDB, is a national data bank that collects, reports, and disclosure of actions taken. Patients' rights under the privacy standards: copy of the privacy notice, access to medical records, limits on how healthcare information is shared, accounting of who the information is given. Patients' rights under the privacy standards also include asked to be contacted in a special way, phone or mail, for example, asked to be contacted in a place other than home or work, examine health information provider's copy, complain to covered entity if violation of privacy is suspected. HIPAA defined permissions: permission to use information based on reason for knowing or use of the information. Special rules relating to research: a researcher must obtain a patient authorization that complies with HIPAA, a waiver of authorization from a privacy board or institutional review board, and a waiver must include extensive documentation as required by HIPAA. Problems relating to HIPAA's privacy rules: some healthcare providers now refuse to provide medical records to anyone except the patient. Compliance with HIPAA slows police investigations and impedes prosecution of crimes and civil litigation. Misconceptions about HIPAA: it does not prevent physicians or hospitals from sharing patient information to treat, does not prevent disclosure to clergy, allows hospitals and physicians to share information with spouse or anyone else, any patient that has identified as being involved in one's care. Misconceptions about HIPAA continued: does not apply to most police or fire departments, may release information about accident victims, does limit information EMTs may disclose. Recommendations: appoint and train a privacy officer, conduct internal assessment of existing policies, enter agreements with all non-employees, service providers, adopt procedures for handling patient requests, implement a notice of privacy process. Revise employee manuals regarding HIPAA standards, train all employees on policies and procedures, retain signed authorizations and copies for 6 years. Implement and enforce sanctions for violations. Establish a complaint process for non-compliance. Ethical concerns with information technology, informatics, wireless local area networks, WLANs, are communication systems used to access patient records from a central database. Voice recognition technology, so a physician inputs information by voice in real time on a mobile device, such as Dragon and other intelligent software. Medical informatics, application of communication and information to medical practice, research and education. Telemedicine, use of communication and information technologies to provide healthcare services to people at a distance. Technology technicians, health information administrator, health information technician require a college degree and certification in certified in healthcare privacy and security, CHIPS. This concludes our lecture for chapters 9 and 10.